I want to spend some time speaking on the list because it continues to make the news, and Aubrey Norton and the APNU+AFC continue to mislead the population. They continue to misunderstand the law. They continue to peddle a false narrative. But I am happy that more and more this issue is being discussed. Because as the issue is being discussed, more and more their ignorance of the issue is being crystallized and made public. Their lack of understanding of the concepts are becoming more apparent and visible. And the falsity of their narrative is being revealed more and more. So, let me start out with what the position is. And we have said it a million times, but it is worth repeating. Firstly, the Constitution of Guyana is the supreme law, and the Constitution of Guyana says that once you are 18 years and over and you are a Guyanese, you can be registered. And once you are registered, you are qualified to vote. There is no requirement that you must be resident in Guyana or out of Guyana. So if you live in Australia, if you live in Sri Lanka, if you live in New York, if you live in Toronto, if you live in Florida, but you are a Guyanese and you are registered, you can vote. If you are not registered, but you are a Guyanese and you are 18 years and over and you live in New Zealand, you can be registered. So I think that is clear. That constitution is the supreme law. It can't be changed other than by a 2/3 majority. Good. The Chief Justice of Guyana gave a ruling when we were in the opposition, in which, after Her Honor reviewed the relevant sections of the Constitution, Her Honor said this, and this was a case filed by me because they were trying with Patterson, James Patterson as the chairman of GCOM, to start a house-to-house process, registration process, to retire the existing database and to create a new one. We went to the court and we made a complaint that you cannot do that. To remove those persons' name on the list, you are violating their constitutional rights. And this is what they wanted to do, importantly, was to remove persons who are resident overseas. They said that as a preamble to the house-to-house registration process in 2019, I think. This is what the Chief Justice ruled, and they never appealed this ruling. They accepted it. In order for the names of the persons already registered to be removed from the list of electors, they would have to be deceased, meaning dead, or otherwise become disqualified, meaning you have to commit some electoral offense, or you must become a bankrupt, insane, those are the grounds upon which you get disqualified. The Chief Justice continues, but failure of registered persons to be present or resident during the house-to-house exercise would not be such a disqualifier, and such a person's name can only be deleted if they no longer meet the qualifying criteria under Article 159(2) of the Constitution. The fact that you are not resident here cannot be the basis of the removal of your name from the list. Why? Because residency was not a basis for you to go on to the list in the first place. How many times must we drill this into the thick skulls of these people? They don't understand this. Today at Norton's press conference, for the first time in a press statement, he admits that he is prepared now to partner with the PPP to change the Constitution and the laws. That was never his position. Finally, he understands that to achieve his objective, we have to change the Constitution. Since he became opposition leader, he has been talking about this. That is since March, I believe, of 2022. Over 5 months, he took to understand this simple concept. Now, he is saying that he's prepared to change the Constitution. But we will deal with the change of the Constitution just now. I'm getting to that. He says in the statement today that the list is bloated by 200,000 persons. He then says that 200,000 persons, based upon statistics from Homeland Security, were granted permanent visas, and 54,000 received visitors' visas. What he wants is these 254,000 people to be removed now from the list. What he doesn't understand is that the 254,000 people who got this visa, permanent or temporary, in accordance with the Constitution and the law now, can vote if they are registered, or they can come and be registered. So I want to make that very clear. He doesn't understand that. That's the only reason why he's citing those statistics. Those very 254,000 people that he's speaking about are qualified to vote in Guyana or to be registered. Why? Well, provided that they are 18 years and over, they are Guyanese. The fact that they get permanent or temporary visa make no difference. Norton doesn't understand that. He still includes that in that statement today. And go back and check that statement. Now they said today that the list is bloated by 200,000 persons. And this 200,000 persons consist of dead people and migrant persons. Now, I have already established that migrant persons, once they are Guyanese and they are 18 years old, they can be on that list. And if they are on that list, they can vote. So when they say that the list is bloated by 200,000 persons, let us assume that 150,000 of those 200,000 are migrant Guyanese. They are lawfully on the list. If they are lawfully on the list, how can the list be bloated? I have to get a blackboard and I have to start to draw this thing now. If they are qualified electors, or they are, how can they be, or they are qualified registrants, how can they be considered a bloat? How? Unless we break this thing down piece, maybe they will never understand it. So that's the first thing I want to point out. Secondly, let us say, remember it's 200,000 they're saying. So 150, let us assume that is the migrants. So I have established that not because they're migrants, they are disqualified. In fact, they are qualified to remain on the list. So if you have 150,000 Guyanese living outside of Guyana on that list, they have a right to be there. They can't be considered bloat. If you have 50,000 dead people, well then take them off. We have no problem with that. Let Charles Corbin, Vincent Alexander, and Desmond Trotman, your three commissioners, go there and remove them from the list. In any event, in the new amendments which we are proposing to the National Registration Act, it makes it now a mandatory process for these names to be removed, and we have said that a million times. So let's move on. Let's move on. I'm taking my time so that people will follow the argument. Today at the press conference, a young reporter whom I wish to salute here tonight, Tamika Garnett, I don't know which press outfit she is working with, but this young lady absolutely embarrassed Norton and the entire head table, including Roysdale Ford, because she said very simple to them, if these migrants persons about whom you are complaining have a constitutional right to be on that list, which constitutional right have been upheld by a ruling of the Chief Justice, which ruling further states that to remove them on the basis of residency would be unconstitutional? On what basis are you saying that Guyanese who are resident outside of Guyana should be removed from the list? On what basis are you calling them bloating the list? Norton can't answer. He could not have answered. All kind of mumbo jumbo. He started to tell the press conference using these song bites that he's famous for. Well, I spoke about a credible list already, and I don't know how you don't understand about credible list. The young lady is asking you the very, very pertinent question that goes to the core of your allegation of lack of credibility. The young lady is demonstrating to you that your allegation that the list is incredible is unfounded. He couldn't answer the question. He couldn't. Then he starts to speak. Then Mr. Roysdale Ford, sitting next to him, attempted to assist him. And he did a terrible job too, because they couldn't answer the woman, the young lady. Roysdale Ford starts to speak about voter impersonation. And in defense of his leader, he started to refer to the leader earlier statement about voter impersonation. Voter impersonation is a completely different thing. What Norton is speaking about is what he calls a bloated list. Voter impersonation is pretending to be someone else and voting in place and instead of that person. That has nothing to do with the list. When they can't answer the issue, they confuse and conflate them. Then Roysdale Ford, in his desperation, started to introduce residency in constituency for the purpose of local government election, and started to say now that the Chief Justice didn't deal with that issue. That is, resident within a community or within a locality or within a constituency for the purpose of local government election. That the Chief Justice ruling didn't deal with that. We agree that was never an issue. It is now because they can't defend their clumsy, uninformed, uneducated positions, and their ignorance is being revealed. They are now running for cover and creating new arguments as they are going along. Today, for the first time, the Guyanese public would be hearing about residency now for the purpose of local government elections, meaning residency within the locality. That has never been an issue, and we can address that. But that is a completely new argument, and it was only used because Ford and Norton could not have answered the probing question of that competent journalist. Let us now take Norton's argument that they are prepared now to work with the PPP, apparently to amend the Constitution. Well, first of all, let us assume that they have arrived at that position now, that they recognize that to get Guyanese overseas off the list, we must amend the Constitution. So the first thing that I want Guyanese in the diaspora to know, in particular in Brooklyn and wherever, Guyanese are supporting the opposition, that they want to disenfranchise you. That's the first thing I want to say to the Guyanese supporters of APNU+AFC. That this political party that you support, they want to disqualify you from ever being registered in Guyana and from voting in Guyana. That is what they want you to do. And they are prepared to partner with the PPP so much that they want to disenfranchise you and deny you of your right to vote in Guyana, that they are prepared to partner with this big, bad, dictatorial PPP to achieve that objective. Do you understand what I'm saying? These people that you have spent so much energy to support and canvass for, they want to backstab you by denying you the right to vote and to be registered in your own country. And they are prepared to go in bed with the PPP, the same party that they are telling you to attack. They are prepared to go and work with the PPP to achieve the objective of denying you your right to vote. So I want to make that point. The other point that I want to make is they promised, as we promised, constitutional reform, but constitutional reform that would be driven by the people and not the parties. We both promised that. Let me tell you what they said in their manifesto. I have it here. APNU+AFC at page 11 of their 2015 manifesto, and I'm speaking to their own supporters, please go and check page 11 of the APNU+AFC 2015 manifesto, and you will see this passage. APNU+AFC recognizes that the Constitution in its current form does not serve the best interest of Guyana or its people. Within 3 months of taking up office, APNU+AFC will appoint a commission to amend the Constitution with the full participation of the people. Within 3 months, they promised that in 2015, with the full participation of the people. If they wanted to change and clean the voters list all the time and amend the Constitution, which they promised that they will do within 3 months of 2015 getting into government, why did they do it? But importantly, they promised that when they do it, it will involve the full participation of the people. And here it is, Aubrey Norton, the leader of that party, is saying to the people of Guyana, he's going to abandon this promise. He's not going to the people anymore. He's going now to the PPP to strike a deal. That is what he's saying, openly and in writing, that he's not prepared to consult with the people anymore as they promise. And they promised the same thing in 2020 election. Check the manifesto. He's telling the people, his own constituency, that I am now prepared. No matter with you people and your participation, I am prepared to join hands with the PPP now to amend the Constitution. We are saying, no, Mr. Norton. We have promised constitutional reform. And we have said to the people of Guyana that we are coming to you and ask your views on how we should reform the Constitution. We are not Aubrey Norton, who make promises for political and narrow purposes. We make promises to the people of our country for the betterment of them and the advancement of their welfare and for the improvement and advancement of this country. So we are not going to, in no secret deal with Norton, to change any constitution. We are committed to a constitutional reform process, and we have laid and passed a bill yesterday in the National Assembly outlining how that constitutional process will take place. And if during that process the people of the country want a different type or requirement for registration and voting, well then that process will determine that. We will not unilaterally impose that on the people of our country. That is our promise, and that is the promise upon which we will deliver. The other issue that Mr. Norton shows a demonstrable lack of understanding of is the registration system that we have in place. This gentleman is completely hopeless when it comes to understanding the registration system. He's speaking about a database or a list that is 14 years old because we had a new house-to-house registration system in 2008. What Norton does not understand is that we have a continuous cyclical registration system which exists throughout the Commonwealth. It registers people on a cycle all year round. It is renewed and renewed every year, every 6 months. You have a claim and objection period and process that ought to take out the impurities and add as the process continues. It doesn't stop. We introduced it, yes, in the year 2003 by legislation. So he's even wrong in relation to that. It's a 20-year-old system. And it will be there until we decide to change it. Nothing is wrong with it. All the other countries in the Caribbean and in the Commonwealth are using that same other system. It is the most effective system. The alternative to that is every time you want to go to an election, you have to do a house-to-house process. Ab initio, beginning from citizen number one. Who got the time, money, and energy to do that? When in a technological world, you can have a list that is rotating, spinning all the time, adding people as they come of age and removing them, of course, when they become dead or when they become disqualified. That system is not going to change, Mr. Norton. That is the nature of the system. And that type of system eschews. It does not permit house-to-house registration anymore. The system has its own cleansing mechanism. When the reporter asks him, Mr. Norton, today, why are you not using the house-to-house, the claims and objection process to clean to make your objections? He said, no, it's ineffective. He can't do it. It's not that he can't do it. One, they are too lazy to do the work. That's the first thing. But secondly, they cannot remove the persons on the list that they're complaining against because the law doesn't permit their removal. Where you going to bring 100,000 Guyanese who are resident in Suriname, in Trinidad, in New York, in Canada? And what are you going to say? What? Disqualify them because they're overseas? The law says no. And why you think they're not going to the court? If Roysdale Ford knows all this law that he seems to think, he wants to tell us that he knows, and Norton got all this political strategy, why is it that they're not going to the court? If you think that the list got 200,000 persons who are unlawfully there, go to the court, man. When they were doing the house-to-house registration process, and they were going to remove the people from the list, I went to the court. And I got the court to say that they cannot proceed. That if they were to proceed, they would be acting unlawfully. Go to the court now and you tell the court that you got 200,000 people who should not be there. A court would gladly make an order like that. I challenge them to do that. Why do you think they're not doing that? Because they will get another set of beating from the High Court all the way to the Caribbean Court of Justice. And I'm saying that long before the case even filed. So nobody can accuse me of disclosing confidential information. So I think that I have dealt adequately and elaborately with the issue of this list. And I hope that I have illustrated and I have demonstrated what the position is legally, constitutionally, that I have explained and illustrated how misconceived Mr. Norton is in relation to this issue. And I have demonstrated and illustrated how false their narrative is, how defective their arguments are in respect of this issue. I know that the press would normally cover or follow this program. And I am hoping that they would use this program to produce many articles clarifying the issues, because it is for the first time that we got from the APNU+AFC their full story. It is the first time they have disclosed so much of their arguments so that we can able to analyze them and demonstrably debunk them. They never before say what was the basis of their objection over the past several months. They were talking about dead people, yes. But they never openly came out and spoke about the migrant people. So I'm happy that they were duped to come out. Or they chose voluntarily to come out. So that they were able to bare their soul, and we are able to respond now.